So I thought it would be a good idea just to start with where Stephen laid off this morning. He ended by quoting the Christian Jonathan Berkley from the Ecclesia think tank. That's not a mainstream think tank. It's a bit Anabaptist, I think, really. But anyway, in British terms, that's not mainstream. It's not even Baptist, but still. Anyway, yeah. Well, it's not the free church tradition in this country, shall we say that? Anyway, he says this: people should be aware that behind many such cases, this is the quote from the man from Ecclesia, there are groups whose interests are served by stirring up feelings of discrimination, of marginalisation amongst Christians. What can appear to be a case of discrimination at first glance is often nothing of the sort. It's more about Christians attempting to gain special privileges and exemptions. And Stephen said this last considered opinion seems to me exactly right. Now that was in the context of the quote of an attack on Mr. Paul Diamond when he was presenting a case. And we're lucky enough to have Paul here. And I thought it would be a good idea if Paul not only could defend himself, but talk a bit about the issue of the strategy of dealing with these cases, because I know a lot of Christians even feel that sometimes these high-profile cases do more harm than good. They polarize, and particularly if you lose them, they don't do any good. And sometimes, therefore, going to court isn't as powerful an option as quiet negotiation behind the scenes. Now, that's not necessarily what I'm saying, but I've heard some parliamentarians say that. Paul, could you just say something about this? Are you here? Yes, here you are. Good.
Just because simply I've heard the great minds, and I don't intend to... I'll make a few comments on it from a practitioner's point of view. I think what I would say, just by putting myself in context, I'm a practicing barrister, so I take instructions, are wide-ranging decisions, which, again, people have different views upon it. And, you know, political campaigns are being waged. What I would say is, if I can call people by their first names, I'm slightly sort of ignorant on the full titles, but Linda and Robin's piece, which I just read. By the way, don't worry what you said about me. I'm totally used to it. I'm a barrister. I'm a bruiser. I have a selection of clients from Vladimir Bukovsky, who's a Soviet dissident, right through to various people, and my main attraction is I'll say it as it is in court, so I'm pretty used to that. So don't worry, I'm thick-skinned. When I heard Linda and Robin speak, I really thought how quaint, how sweet, how entertaining. We've had all that here. We've gone through that stage. We've run all these arguments in our domestic courts. The judges may not be kind enough to repeat the arguments, or the judges may have expressed them, I think, like Judge Walker would have expressed them in a dismissive fashion, but they have been run here. So we've run arguments of duties of mutual accommodation, that there should be no denial of service provision, but the judge should only consider a denial of service provision where no alternative service exists. So the example given of that photographer in Mexico, what's the big deal? I think there was a bit of discussion. There's hundreds of photographers, so we'll just go to a different photographer and they can provide the service. Well, we've run that argument. You don't have to go to this bed and breakfast that has Jesus is Lord on a carpet as you go in, and if you go to their website, actually says we are a Christian bed and breakfast house, we have Christian morality here. You don't have to turn up at that guest house because there was another suitable bed and breakfast half a mile down the lane that would have gladly had you. The courts have rejected those arguments. They've said it's rather contorted, and there'll be better minds on it than me, but as you know, they've rejected that the primacy of the discrimination policy, that there should be no exemptions from it, and in fact they've rejected reasonable accommodation, and in fact they've even rejected there's discrimination on grounds of religion when there's a clash between religious and same-sex rights. So we've run those arguments, and we've also run other arguments such as religion shouldn't be cross-matched with discrimination. Why is discrimination given such primacy? Someone said, well, why is religion so important? Well, it's so important For one reason, is because the lawmaker has said it's an important right in the First Amendment or Article 9. It's got specific provision. And discrimination, certainly in the European context, is an additional right under Article 14 of the Convention, but it seems to have, it's religion that has to be justified against discrimination. I think what I would say is, I mean, the issues as a litigant in court are just very, very different. I mean, they're just so different from what we're hearing today. I mean, the processes of, as many of you will be aware of, judges making decisions, of course, when there's the lawmaker to make decisions. And some of the comments I heard today made a lot of sense to me when the New York State said, well, the legislature can do this. And in a culture where we have a sovereignty of parliament, there is a permissive capacity of the lawmaker to make laws and that the majority populations may want. But the evidential rules of courts, the procedure by which courts come to decisions, they're really, really lacking. I can't possibly go into it at the moment, but how courts adjudicate religion and the important elements of religion. There's the issues that come up are the selection of cases. The executive very often can choose the cases, who to prosecute, who to bring up, which cases are important, which forms of discrimination they take very, very seriously, which forms of speech are hate speech. They're the ones that come before the courts. You haven't got an open book choice on what cases come before the courts, and your capacity to engineer a case before the courts, and believe you, parties do seek to engineer cases before the courts, is quite limited, but it is possible. There's also, I'm going to try and be entertaining at some point. There is also scale of resources. So this is my attempt to be funny, but it won't be. But anyway, and the scale of resources. I mean, the worst case I ever did was I did a case for the Pro-Life Alliance before the Information Commissioner. There was a case a few years ago in the United Kingdom where a lady had a cleft palate, and a lady had a child aborted because of a cleft palate as a severe disability. It attracted a considerable amount of press interest, and the response of the Secretary of State for Health for that was to ban the publication of all abortion statistics on the grounds that this was intrusive to doctors' welfare, and of course trying to create a climate where there would be effectively abortion on demand. I was instructed by the Pro-Life Alliance. Alan Johnston, then the Secretary of Health, declared the Pro-Life Alliance potentially as a violent organization endangering doctors' lives, not on any evidence at all. And we went into a security session, which is the first time I've ever done a security session. You actually turn up at a court, they say, where's my trial room? They say, we're not telling you. It's a rather novel experience, and you find yourself in some obscure building in South London. And I found myself against 13 lawyers against me. My only attempt at a joke in that is that while we were I didn't have security clearance, which makes it very difficult to do a security clearance trial. It's a novel experience. Anybody who knows me will understand why they didn't give me security clearance. I'm a very good after-dinner conversationalist, and I normally bab every secret everyone's ever told me out after a good glass of wine. So I didn't have security clearance. You have to go in and out of the room with various bits of information given to you. It was a ludicrous proposition by the Secretary of State that the Pro-Life Alliance was a dangerous, violent organization. And I thought it was all going quite well, but the second day in of this trial, there was an American abortionist doctor who just happened to be shot called Dr. Stiller. I don't know if anybody remembers that. And it was on the second day of the trial, and I was going, this is absolutely ridiculous. I mean, this never could happen. And then this guy was shot, and then this very eminent lady who was a countess and involved in the Pro-Life Alliance had to give evidence. And she goes up into the box and she says, I want to express my deep regret at the killing of Dr. Killer, because of course that's how he was known. That's my attempt at a joke. It's obviously fallen flat. I apologize, it wasn't bad taste. But I think the point I'm trying to make in this is quite simply this lack of resources. case selections. I have 13 lawyers against me quite regularly. Evidence is selected. We have the Human Rights Commission, taxpayers' money galore. When we did the Johns case, I mean, I'm always quick for the press always sitting 3 deep behind me. They submitted that it was the duty of the state to protect vulnerable children from being infected, their word, infected, by Judeo-Christian values of sexual morality. Now, I don't miss an open shot at goal. So, of course, I jumped up, oh, I object, what terrible language, blah, 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 blah. They endorsed it, they didn't withdraw it, they held it. Now, that was reported in the press subsequently that the Human Rights Commission had used the word infected, and they said it was a mistake afterwards, and it had gone through. Absolutely not true. It was raised in court, and they defended it in court. But imagine if I'd said infected. Imagine if I'd used that language. And I accept, I had a bit of a running-in with Mumby, but I enjoy running-ins, and that's what I'm partly paid for, because I'm a bruiser, and I have a running-in with Mumby. But he didn't seem to comment on that particular word, and he mentioned a lot of things. Also, most of the cases are against government institutions or publicly funded bodies, local governments, government departments, resources, and I've never had legal aid for any. I used to have legal aid a lot in my general practice, but I've never had legal aid for a religious rights case, even when we ran cases in very similar natures to other religious groups and gone to the same legal aid board, and we've said to them, you granted it for this religion, can this particularly Christian person have it? And it's always refused. I think some of the issues that I said are coming up. So I say to the Americans, I mean, there's positive and negative. I mean, as I said, it sounded very twee what was being said. I think you have to accept that we have run those arguments. I think the problem is we're in a, now Judeo-Christian values have been undermined. We're slightly lacking boundaries, and I think it's the lack of boundaries which are a problem. It's only, human rights are adjudicated by its own human rights morality, which seems to be limitless. There's a considerable, some people have commented on the suitability of law being involved in morality, but I'll leave that to the great minds sitting here. I know that people laugh at the sort of political realities. Somehow academics look at the cases and say, well, this meant this, and this said this. When you're on the floor of a courtroom and you're in a political campaign, and actually I accept, I'm instructed by parties who are running a political campaign, and my opponents are likewise in that courtroom running a political campaign. The argument that the politicians use later, the line is drawn thus far but no further. Perish the thought that we will cross this line on benefits for same-sex couples or same-sex marriage. Both parties are already in their rooms planning and plotting the next stage of litigation. So if something like same-sex marriage does come in the United Kingdom, which it may well come in, there will be a whole raft of new litigation, what's going to be taught in schools, should established churches marry such parties. I think it would be inevitably impossible to resist, and certainly in the United Kingdom's demographic context, with calls for Sharia law, or would better be made multiple Muslim marriages. And regardless of what courts in Vancouver say on Mormon establishments in Canada. I have to anticipate, which I am anticipating because that's my job, a whole raft of new litigations, and I advise my clients on new and potential litigations of equality denial or new forms of hate speech which are coming up. I think what I would say is, trying to end on a positive note, because I think there are, believe it or not, positive notes, no need to be naive, but I think the situation is ultimately, I feel, more political than legal. There are some areas which are still, I feel, very strong in the United Kingdom, and that is autonomy of organizations, including religious organizations, and I still think free speech is quite strong. The problem with the selection of cases is that the state will prosecute and select who to prosecute, and it's the chilling effect that flows from that. But very often the party will ultimately win in the European Court still on free speech. I think you know, there's some sociologists here, and I suspect most of it is in the sociological realm of demographic change, value change, and movement change. I don't know if that's been any help. I'm trying to make, I had a couple of jokes, and of course I lost them, and I said a lousy one, but anyway.
Good. Well, thank you very much. Could I then just pick up one thing you said, which was about where this might get with Muslims and polygamy, because that meshes into what one or two people have been raising with me and what came up in the last session, which is if you in fact change the definition of marriage so that it's, say, between consenting adults or something like that, doesn't it let in more than just same-sex marriage? And I think there was somebody who wanted to comment on that. Oh, there you are at the back. Yes, thank you. Would you like to just say a few words? You were talking to me about it.
Yes, thank you.
Yes.
My name is Lisa Noland. I am a sex historian. I track sex culture for my sins. Work with kids. I'm a lay chaplain at a school. Oh, thank you. At a school in Bristol, and I've been very interested in today's events. Fascinating. To be honest, I felt that things have been slightly dated, however, in terms of two respects. First of all, in terms of the sex culture, oh, and sorry, the other thing is I am a convener for a working party on the sexualization of children, and we work in Parliament, so we work with parliamentarians who are also concerned about the sexualization of children. But two brief comments. First of all, we hear a lot about orientation and the dignity and respect for each person's orientation. And as someone who's tracking this, I don't believe we know what we have let loose here, because there are several orientations that are very much coming out and saying, damn it, me too. When will we be allowed out of our closets? In terms of the polygamy one, yes, Canada effectively closed the door. This is in November 2011, and the best polygamy kind of site is Poly in the Media or Poly Percolations. I go there, I live on that site because fabulous global news about what's happening in poly world. Polygamy, so we think of heterosexual, generally alpha male and various females. In Canada, they lost that. In Utah, a chap named Cody Brown has done very well, actually. He is pressing for decriminalization. He made it from one layer to the next. He and his wife, it's a huge, huge, big media campaign as well. So I guess watch this space, certainly in Utah. But I'd like to read the other group that often gets mixed up is polyamorous. Polyamorous people are often bisexual, although not uniformly. But essentially, poly people believe in multiple partners. So they could be gay, 3 gays, 3 lesbians, one of each, or whatever, various combinations. So they can be homosexual, bisexual, or heterosexual. According to their lawyer, most recently, in fact, I have this, if anyone would like this handout, please just email me. According to, this is on the Poly site. Polyamory, legal in Canada since 2011. According to Poly lawyer John Ince, quote, gay history shows that liberation comes in steps. First, gay relationships had to be accepted as legitimate and non-criminal, which is exactly what Cody Brown is now pushing for in Utah. Now, back to John's quote. Once that occurred, then gay marriage followed. I think our normalization will follow the same course, particularly if it's my orientation. If I'm bi, and I have a lovely husband, and I have a fabulous girlfriend, and together we do family. See, that is happening now. They are coming out now. Just on Good Friday, in The Guardian, there was a huge article about polyfamilies. Basically, these were heterosexuals. But so we have The Independent, we have The Guardian, we had a polyamorous folk came out on ITV. last August, and there were 2 heterosexual polys and 1 bisexual poly. Very much this is to watch this space, if nothing else. The other thing in terms of polyamory as a sexual orientation, I would like to, if anyone would care for a quote, in terms of downloading this, Polyamory as a Sexual Orientation by Ann Tweedy, University of Cincinnati Law Review. And she is very much saying, we're here too, and we're tired of being discriminated against. So that's my first point. Sorry, may I just very quickly, my second?
Very quickly.
Very quickly, thank you. I feel really bad because my kids are being sexualized in a huge way. I've worked with adolescents for 3 decades. I will leave these with my colleague Chris. You may have a look. Terrence Higgins Trust is a gay group. Now it's come into my school. It's been given £200,000 to go into school to make, quote, sexual health champions. The stuff that kids get, and also, by the way, it has NHS endorsement. The stuff that kids can read is pure porn. I won't even tell you any more, but please, if you'd like to have a look. And where I'm going with all this is, with my parliamentarians, they dare not open their mouths about this. It's anti-gay. If nothing else, please, regardless of where you're at with the same-sex marriage issue, children, kids, and sex are toxic. The sexualization of young people is really scary in terms of all sorts of social effects. So please do have a look if you don't believe me, and I'd love to be in contact as well. Thank you.
Good, well, thank you very much indeed. Yes.
Did I hear you say we lost in Canada?
Okay, your polys, I'm sorry, your polygamists lost, yes. Yeah, your polyamorists actually feel they won. So there was a difference there. Your polyamorists felt very good about the court decision because as long as you don't have a formal wedding ceremony, then in fact, like the Mormons did, see, that's not okay. Yes, thank you.
Right. Now, just another point that was left hanging from this morning was the whole issue of human dignity. And John, can you say a few more words about that? Because somebody thought that perhaps you ought to have had more time this morning to talk about that.
John was, suggesting that dignity is a key concept, and sociologically speaking, it is, and philosophically, it so to speak was. Its popularity in modern Europe it can be dated back to the first article of the West German Constitution in 1949, which is a sort of Christian document arising out of the horrors of debacle of the previous 30 years in Germany, not just the 15 Nazi years, and no one could blame them for putting this concept there. It's a sort of shorthand for what I was talking about when I talked about human rights as acknowledged by Roman lawyers and Christian theologians and great philosophers. Dignity stands for the human as spiritual and therefore as above animals or other animals. We're animals, but we're spiritual animals. And so it points us to what gives us equality. We actually de facto unequal in countless ways amongst ourselves, but we all have this character of being above the rest of the animals by being human. And dignity is a pretty good way of saying that. But Chris was saying, well, the term the common good is now sort of marginalized because it's treated as having been captured by Christians or Catholics or something like that. Similarly, the term dignity, alas, is, I fear, in process of being captured by the forces of constructivism and such like denial of essence. And denial of essence sounds good, essentialism sounds bad, but actually, of course, it's a radical denial of equality. The only equality we have is as being all essentially human. So what sounds cutting edge and so forth is extremely bad news and points us towards Nazism and such like, radically anti-civilization and anti-rights. So if dignity can be kept to its classic moorings, well and good, and I'm happy to use it like anyone else, but it's in process of it's being captured by the euthanasia movement, which takes an utterly superficial concept of the dignified and punning on that equiparates it with human dignity or loss of dignity. So there's an ambiguity there which they trade on. It's been captured partly by the homosexual movement, which calls itself dignity in various parts of the world. And so it's got at least as many problems as the common good. We should use all these terms. They're all ours, but we should be aware of what uses they're being put to.
Because you were suggesting, of course, that there is a Christian background to the use of dignity, which and you can ground the notion. Once you get rid of the Christian background, there's a question from a purely secular point of view, what grounds the notion of dignity, isn't there?
Yes, well, I'm hesitant to make that argument as bluntly as that, because I do regard, I do think that there is a philosophical tradition which isn't fully dependent on Christianity or revelation, and is valid, and could even, in some senses, be called secular, although Plato and Aristotle are both believers in the transcendent and in the God, if not precisely creator, it's still as good as. So I don't want to make it just a religious doctrine or religious conception, let alone a Christian one. Though, as we can see, de facto, when civilization has been Christian and turns its back on Christianity, then it tends very strongly to turn its back on the sound philosophical tradition that Christianity welcomed and appropriated.
Good. Right. Yes.
I think it was mentioned earlier, maybe it was by Linda, that there is the question was asked rather, where are the areas of bias now? I think there's a massive area of bias, and it's in the social sciences. The investigations into homosexual parenting, to put it even politely, are incredibly unscientific. They're absurd. They make a nonsense of investigations. You have the studies with volunteers, adverts in the gay press, in gay venues. Can we have people to take part in this study? Oh yes, I'll do that. There's not proper control groups. It's self-reported. They are often tiny samples. Poor matching, poor controls for confounding factors. There is very, very little that even approximates to anything like proper research. These abysmal empirical standards are very difficult to find in other areas of the social sciences, and I've dealt with family studies and demographic studies for a very long while. I suppose we saw some of it in the childcare studies of the 90s, where people were frightened to record adverse effects of daycare on children, or they just filed it away instead. We have some leading actually homosexual researchers themselves who say that the research proves absolutely nothing because it's at a poor standard. A lot of it doesn't test a proper hypothesis, it just tries to prove a negative, which is impossible. But of course it gets a big press. It's advocacy research, it's very skillfully publicised, and I'm sure legislators often do not know what they're handling. They don't look at the detail of the methodology, they don't look how the sample was taken, they just do not know these things. The responsibility, I suppose, in the end rests with peer review, which seems to be hopelessly corrupted here, because it doesn't want to appear politically incorrect in turning away these studies. There seems to be an immense amount of resources going into all sorts of gay studies now. You can get money for virtually anything, anywhere. One example, I think, of the abysmal standard was provided by the research quoted, not in detail, I wish they had, in the Commons to get rid of the need of a father from law. This was over assisted reproduction, where we had, I think it was Evan Harris saying, good riddance, we don't need fathers. I've got evidence to show, evidence to show. And I remember being one of those that asked for this evidence. It was 22 lesbians who self-reported on children who were 2 years of age. You can extrapolate nothing from that, what they're going to be like later on. And in fact, even the researchers said that you couldn't predict anything from this. And in fact, somebody else had observed these lesbians and found that they in fact weren't doing too well compared to a heterosexual sample. So what do you make of that? So I'm just putting out a message. Unless something has been done, an astounding study, controlling properly, obeying all the rules has come out in the last couple of years, be extremely careful when anybody waves the social science banner over gay studies. Please.
All right. Thank you. Yes. Of course.
Thank you for that comment. And I recently edited a volume called What is Parenthood? It's interdisciplinary, and we have a couple chapters on social science and so forth and so on. But one thing I did learn working on that volume is it's certainly true that there are some flaws with some of the early studies, but there are some more recent studies that are more longitudinal and that are not vulnerable to some of the criticisms that you're talking about. And here in the UK, you have Fiona Tasker, you have Susan Gollenbach, you have Michael Lamb, and you may disagree, but these... Okay, all right. Well, I don't think we're going to make any progress. I just say to the rest of the people in the audience, people have recognized the limits of some of the early studies, and there are some, as we have more years of experience with this, there are some longer assessments, and I would just urge people to look into that.
Right. Any comments? Yes, Robin.
Actually, I think Linda and I come out the same way on this. So there was a live debate in the United States for a while about whether, for example, children raised by their biological parents who were not married. So in other words, trying to isolate the value of marriage to those children. And those studies for a long time didn't exist because there simply weren't enough families that to provide a decent control. So you would have to compare children raised by two biological parents who happened to be married to children raised by two biological parents who decided not to be married, and then look at them over time and doing a regression analysis. So I think it is very difficult for the studies early at the beginning of a social change, in fact, to quantify or to say anything meaningful about it because the ends are very, very small.
We've heard in this session and in previous sessions the word essentialism. One thing that struck me is that it seems to me that in a lot of talk about homosexuality nowadays, it seems to be talked of as itself very essentialist, that you are a homosexual or you are not. It's something that you are intrinsically. It is your nature. It is, in fact, your identity. And I just wonder how this squares then with the anti-essentialism we find going on in other areas. It does seem rather curious to me. I don't know if anyone has any comments about that. Yes?
Thank you. One of the finest studies of human sexuality was conducted by Edward Lawman and associates a number of years ago in America. And he, in the opening chapters, talks very much about this. And he says that the evidence is commonly assumed to support essentialism. He gives examples of left-handedness and things like that. But he says that's not the way the evidence works out in practice. And he comes out quite strongly and clearly and says that that's not so.
Well, certainly if race isn't an essentialist property, it seems very hard to say that homosexuality is, because I thought there's even less, that's much more a behavioural thing. Anyway, it just struck me as being a very curious thing in the way the argument is sometimes set up. Yes. You raise it first, yes.
So there's a concept in this world. It's called, I'm sorry, thank you. It goes by the name of strategic essentialism.
Mm.
Anybody heard about strategic essentialism? Thank you. No, it's that in terms of making particular, well, you'll correct me if I'm getting this wrong, but my understanding of it is that this is an argument that's made in the political domain, where essentialist arguments are likely to be more successful, and therefore there is an attempt to build an understanding that portrays it as essentialist in the terms in which the debates in other areas take place. But that doesn't necessarily mean that in other contexts essentialism is being bought, and indeed I think in most contexts, I come back to the point I made earlier on, that essentialism would be regarded as problematic, to say the least. What's interesting about the debate, however, is, so there's a lot of language games going on. What's interesting about the debate, however, is who it matters to and when, whether the categories are or are not essentialist. And I think all sides are playing this game in various ways. So the question of whether there is a gay gene or not could go in either, I was going to say in either direction, but you know what I mean, could be used in support or opposition to particular arguments with regard to legalization. So I think there's a lot of game playing going on both sides, and making of arguments strategically, and it's very difficult to cut through these debates and see what people are actually arguing because of the I'll make this the last point, because of the different forums in which the arguments take place, right? So in other words, particularly in contexts, and I think the United States is a prime example of this, but the UK is becoming more like it, particularly where this is likely to end up in litigation. Some of the debates are being formulated in order to appeal to particular arguments that can be made in the legal context. And that's a relatively new dimension to the political debate in the UK. But I think it's going to be an increasing issue, so that the arguments become political arguments, but with an eye to how they're going to play out in a legal context. So I think that's a game changer in terms of the way in which the discourse carries on. And unfortunately, I think it's a flow over from the debates in the US, where I think that's precisely what happens as well.
Another point I just wanted to raise quick was in the last session, it was suggested that the only difference in California between civil partnership or whatever it's called there and same-sex marriage was moral disapproval, as if moral disapproval was something subjective, irrational, and totally to be discounted. Now, that's a big assumption. I would have thought moral disapproval might be a rather thick notion of putting forward reasons to do with goodness knows what that can be then argued for in the public place. It doesn't seem to me to be something that's there, oh, that's moral, we'll get rid of that. It seems to me it ought to be a very serious point to be argued with seriously, right or wrong. So I just wonder if there's a rather curious philosophical notion of morality being just a motive or something, going back to logical positivism. You find that does infect debate sometimes. Yes.
I'm not even convinced reason dominates. I mean, some of the cases that we've done, or I've done, evidence has been produced of X, and where the evidence produced of X produces an outcome not desired, they say Parliament has said otherwise, equally irrationally. So I'm not even convinced what does reason say dominates the debate.
No, well, I'm not quite sure then what does dominate the debate. In one law case, and it's the one about the Methodist minister's position, I was rather concerned to read that even the common law has to be updated. The judges referred to the time-honoured role of updating the common law, making it more suitable for modern circumstances. Well, that means you change what the common law is in, looks to me, in according to the prejudices of whichever judges are judging the case. And that's very ominous.
The essence of the common law is traditional development. You can't have the common law.
But isn't it also tradition? But isn't it tradition and precedent as well?
Of course, but I'm sorry, I'm looking at Ruth here, who's equally puzzled by this. Sorry,
I'm sorry, I'm an interloper, but I'm a lawyer. I mean,
Yes, I'm only a philosopher, so do correct me.
I mean, the whole point about the common law is precisely what you said. It does, albeit glacially and inchingly, it does adapt to modern circumstances. I don't know what the
But it is based. It isn't just based on judges' prejudices. It must be based on tradition and precedents and case law, etc.
Yes, but they still manage to move forward. I mean, just one example that comes to mind. I mean, correct me if I'm wrong. I haven't taught law for a long time. It used to be the common law that a husband could not rape his wife, right? Because they were married. You know, ergo impossible. The judges work their way through that, and now a husband can rape his wife. I'm not saying I necessarily approve of this change, but they do move. And Lord Denning, of whom everyone has heard, was a hero and much loved by students and the foundation of many biographies and books, precisely because he took the law and shook it up. And sometimes he was overruled, but very often he wasn't. So the common law does change.
But doesn't that open the floodgates to judicial activism?
Absolutely.
Yes, so it could be dangerous.
The Supreme Court, you're subliminally aware of it if you read the papers.
Sometimes it can be a good thing.
Sometimes equally it can be a good
thing. Yes. But it could give enormous power to judges, though, couldn't it?
Going to respond to the prior point, which is I think part of the difficulty with the question of marriage isn't really about essentialism. It's really a problem of the nature of marriage, and in many ways the state has been damned by not trying to enforce certain visions of marriage on people. So for example, it's a very difficult claim to make in Goodrich that marriage is about the rearing of children when we allow lots of people to marry who don't rear children. So we have a problem of under-inclusiveness. It's really a difficult proposition to say that it's about procreation, because people like my parents who adopted could marry all day long in every state in the United States. So that's another problem of under-inclusiveness. And so what you really have is a sort of, it's like an onion, a progressive peeling back of layers where we say, no, marriage wasn't about that because the state didn't rigorously enforce fertility tests. No state, marriage wasn't about this because we didn't make everybody have children. And then at the end of the day, you're left with, like, in the middle, it appears to be nothing. And I think that's why it then seems to reduce to this idea of moral disapproval. And I think there is a more robust conception of marriage, but we let go of it in the law in some ways that's hard to get back from.
Right. Good. Yes.
Thanks. You talked about judicial activism, and since I come from a civil law system, I'm minority here. So this is to witness that what you have been dealing with, meaning the courts taking care of same-sex marriage and similar rights, it's something that has become more and more usual even among civil law systems for a couple of reasons. The first reason is that same-sex marriage claims are believed to be human rights, and therefore they are kept out of parliaments where you have majority rules, and they have become part of constitutional or Supreme Court's decisions. And this is very, very important because this turns to more delicate and different, absolutely different arguments. You cannot use the same arguments in courts and in parliaments. And therefore, equality and dignity play such a strong role. Second, they are believed to be a form of protection of minorities. And precisely because they are 2 or 3%, they need to be protected. If you go before a judge, that's the reasoning that he takes. And the third, I talked about Southern Europe, and I said that the vast majority of European countries have reached some sort of balance between same-sex couples and traditional couples through legislation. But this has taken place after a long way of court decisions that have been acknowledging rights, specific rights to same-sex couples. So you have rights that used to be attached to the marriage, that were detached from marriage and accorded to same-sex couples or unmarried couples. And this paved the way to new new balances of rights through parliaments. That's why we are moving towards the same way, meaning the courts playing a leading role.
Right, thank you. Now, does anybody else have got a... Yes, good.
So I just wanted to say a few things about moral disapproval
Yes,
in the
quite,
US
yes.
context. So we're in Britain, and of course the classic Hart-Devlin debate, which John Finnis will know very well, was whether moral disapproval was a sufficient basis for criminalizing sodomy, because the Wolfenden report had recommended decriminalizing sodomy. And in the famous exchange between Hart and Devlin, Devlin argued that a community's sense of that something's immoral should be a sufficient basis for using the criminal law. And Hart said, surely we're not going to, criminalize behavior because it makes a man on the Clapham omnibus sick. Without more, we want to think about reason and sort it out and so forth and so on. So there's a very famous British precedent to this law morality question. But in the U.S., I just want to say two things. One, Lawrence versus Texas, where some of that language about moral disapproval alone is not enough comes, there the issue was, can Texas have a criminal law that punishes only homosexual sodomy, right? Singles it out, and not sodomy in general, which most laws had been. And it's there that the court talks about the right to privacy that Griswold recognized, that Eisenstadt talked about, that sort of should protect the private, consensual, intimate conduct of two people of the same sex in the home because of dignity and liberty and so forth and so on. And the fact that the community, that there was disapproval of that conduct was not a sufficient reason to use the power of the criminal law to punish their conduct. Okay, so Lawrence becomes an important building block for contemporary debates about where else do we talk about moral disapproval? Is it also insufficient, say, to prevent them having access to marriage? Lawrence was very careful to say, we're not taking a stand about the marriage debate. We're just talking about using the criminal law. But of course, everyone argues about the import of Lawrence. So it's important to understand the US where that comes. The other thing I want to talk about is an interesting point Robin made, which is a thicker conception of marriage. I would recommend to people a 1992 article by Carl Schneider called The Channeling Function of Family Law, which is published in the Hofstra Law Review. And I wrote a piece a few years ago revisiting the channeling function. But anyway, and that was Cardozo Law Review. But Schneider basically said one of the important functions of family law is to channel men and women into valuable social institutions like marriage and parenthood. And the law has various tools to do that. Now, if you can no longer use the criminal law to ban the use of contraception by married couples, which Griswold says you can't do, then you have one less tool in your toolkit. Right? And if you start breaking down distinctions between marital and non-marital children, then you have one less tool. Because what the Supreme Court said is you can't punish children for the irresponsible sexual liaisons of their parents, quote unquote. It's unfair, it's unjust, because there's no individual responsibility for the circumstances of the birth. So one by one, we've had these various steps that have broken down distinctions, made marriage less significant for certain purposes, like access to reproductive technology, access to adoption. And so what Goodridge was dealing with was a situation in which the state says marriage's primary purpose is procreation, yet we have all this evidence that they no longer tightly enforce a link between procreation and marriage. So in terms of the evolution of the law, they're trying to assess rationality based on how things currently look.
Oh, thank you. Yes, Stephen.
I just wanted to return. Oh yeah, sorry. Just return briefly to my analogy that was brought up in the last session. The analogy I drew was between the hoteliers that want to say no to accepting a gay couple into their hotel, and a hypothetical case where some hoteliers want to say no to a mixed race couple. And in each case, They are offering theological justifications for their position. Clearly, if you want to treat these two cases as different, if you want to allow an exemption in the first case but not the second, the onus is very much on you to identify the difference between the two cases that justifies treating these individuals differently. And some people here have thought that they can do that, and they've come up with some suggestions. So Dermot O'Callaghan suggested that the fact that race is genetic but homosexuality is not is a relevant difference. And he also suggested that the fact that it's the homosexual behaviour rather than the person that's being objected to is also a relevant difference. Neither of those two explanations are good enough, and they both fail. Here's why. First of all, I deliberately chose not race but a mixed race couple. The hotelier is going to accept a black person into their hotel room. They will accept a white person into their hotel room. They will not accept them going into the same room at the same time because of the behaviour that they are going to engage in that room in private. It is the behaviour that they're objecting to, not the person. So that explanation won't do. So far as the genetic basis is concerned, are we going to suggest that, for example, a hotelier that was happy to allow Muslims into his room, but for theological reasons won't allow them to spend the night because they're going to take the prayer mat up there and start praying to Mecca, and that is something that they are not happy about going on inside their hotel. They have theological objections to that. Are we going to say that, well, that's acceptable because after all, it's not genetic. It's just, it is only behaviour, so we should allow this particular exemption. If you're going to make those exemptions on that basis, you're going to end up with some ridiculous judgments. You have to come up with far better criteria than that.
Right, Chris, John, yes?
Just about the moral disapproval issue, the Hart-Devlin debate that Linda McLean referred to was an intellectual catastrophe because both parties to the debate, who thought they were having a serious debate against each other, made the catastrophic blunder of assuming that the morality that they were talking about was positive morality, as they called it, the actual mores of the tribe, as it were, rather than what people who actually morally disapprove of something, some act or conduct, really think, which is not, I'm following the mores of the tribe, rather, I think this sort of conduct is harmful, is bad for people, is not a good way to live. And that perspective, which is in fact the ordinary legislator's perspective and the ordinary citizen's perspective, simply wasn't present in the Hart-Devlin debate. So that was a catastrophe, number one, and most law school professors are completely unaware of this elementary sophism and teach the debate as being serious and important, which it isn't, except sociologically and for its vast effect on law school professors. Secondly, another catastrophe was that in the English-speaking world, the distinction drawn throughout the civil law world between public morality and private morality, especially in relation to the criminal law, was never systematically drawn. And so criminal laws made crimes out of secret, private, undetectable, adult, consensual behaviour such as was perhaps involved in Lawrence against Texas. Had the distinction that was observed in civil law countries been observed, we wouldn't have had Lawrence against Texas, and we wouldn't have had the absurd glissade from, oh, well, it's no longer criminal, to, therefore, it's basically an approved or socially acceptable, possibly, and approved form of conduct. So these two intellectual disasters, one of them sort of built into the law and one of them built into academia, which have conspired to make all this a bit more messy than it need have been.
Good, thank you. So last question from Chris Abdon.
So I want to try this on the company. Throughout the discussion, it has been said, well, you can't link marriage to procreation and children because we allow people who have no possibility of having children to be married. I want to question that. Would you apply it to something like murder? We define murder as sort of the intentional killing of another human being, but then we qualify, well, there are occasions where the intentional killing of another human being is not murder. It's manslaughter. Well, it's not intentional. It's manslaughter. It's death on the roads, or it's self-defense. Or it's unintentional killing. Those sorts of things. Now, that doesn't. The fact that we qualify them and that there are instances that don't count as murder does not mean we resile from the definition and the category of murder. It still exists as a definitional category. I think what's happening in this debate is we're saying because not everybody on the planet can get married and have children, therefore we're going to redefine marriage, seems to me nonsense.
Good. Well, I think that we better draw it all to a halt, as the next item on the agenda is a book launch, and it was perhaps going to be down in the cloisters, but it's a bit drafty there, so I mean you can always stand around in cloisters if you want to get cold, but it will be in the old kitchen from about 5:30. So thank you very much, and thank you for all those who've spoken this afternoon.